Thank you all for joining us today from wherever in the world you are. My name is Rahul Donde. I am counsel at Levy Kaufman Collar, a law firm in Geneva. I am also the Global Events Director of Young ICCA. I'm joined today by my colleagues at Young ICCA, Masaki Kawasaki, who is also an associate at Nishimura and Asahi in Japan, and Shaimi Kim, who is a senior associate at Lee & Co. Both Masaki and Saimi are events coordinators at Young ICCA. This is the third Young ICCA webinar that we are organizing that we've put together today. It's the third in a series of interviews that we're doing with prominent arbitration practitioners across the globe. We do have several other events planned in the pipeline, and you'll see notices and identification of those events on the Young ICCA website. So I do encourage all of you to visit the Young ICCA website and keep abreast of all of the activities that we're currently pursuing. There's also a Young ICCA mentoring program, and you will find all of the relevant details on the Young ICCA website. We are extremely happy and privileged to have with us today as our guest, Ms. Yoshimi Ohara. Yoshimi is one of the leading arbitration practitioners in international arbitration, and her reputation kind of precedes itself. I don't really need to make an introduction, but it is my pleasure to do so. Ms. Ohara is a partner at Nagashima, Onu, and Tsumatsu at the Tokyo office. She has considerable experience in international arbitration, both investment arbitration as well as commercial arbitration, and she has represented clients in international arbitration proceedings in different seats and under various rules, including the ICC, ICSID, the AAA, ICDR, SEAC, and the JCAA. Interestingly, and this is an issue that we will be touching on in the course of our webinar today, before she launched her international arbitration practice, she was active in the area of corporate transactions and IP dispute resolution. She has a very strong, in fact, corporate and IP background, but then she's also added on considerable expertise in a number of different areas, including joint ventures, investment, infrastructure, energy construction, and insurance, just to name a few. Ms. Ohara also has an active practice as an arbitrator, where she sits both as a sole arbitrator and as well as president of a 3-member tribunal, again before various institutions, including the ICC, the SEAC, the JCAA, the KCAB, and ad hoc arbitrations. While she runs an extremely active, and I've said almost hyperactive practice of international arbitration, she does also take the time to contribute to the academic side of things. She is a professor teaching international arbitration at Keio University Law School, where she has been since 2014. She's also played an active role in facilitating soft law in international arbitration, and she's been a member of the task force of professional conduct of counsel, and as well as the task force that put together the conflicts of interest rules of the IBA Arbitration Committee. Ms. Ohara is also a member of a number of international arbitration associations. She's currently a vice president at the ICC Court, a governing board member of ICCA, and a board member of the Japan Association of Arbitrators, as well as the Swiss Arbitration Association. So thank you very much, Ms. Ohara, for joining us today. It is truly a pleasure for us here at Young ICCA to host you. We will be asking Ms. Ohara a series of questions today over the course of the next hour or so, and they will broadly cover 4 topics. The first topic will be building a career in international arbitration. The second will be her standout career moments. The third will be diversity in international arbitration. And the fourth will be tips on how to get your first oral pleading experience. We have received a number of questions from those of you that asked those questions to us at the time of registration, and we have included your questions under the 4 heads I just mentioned. Ms. Ohara has also kindly agreed to take a few live questions. So if you do have questions that you think of in the course of this webinar, please feel free to ask them. And in doing so, please use the question and answer box that you have on the screen, at the bottom of the screen in front of you. Before we begin, and I must say these are the final 3 points that I have before we really begin, but a few housekeeping matters that are important and that must be covered. The first is please use the question and answer box, as I've already mentioned, instead of using the chat function. It's just easier for us to keep a track of the questions as they come in. Please feel free to ask whatever questions that come into your mind. The idea of this webinar is also to be a little informal and to give you access to one of a leading arbitration practitioner. So it's a behind the scenes kind of experience. Feel free to ask whatever questions come to your mind. This webinar is being recorded, and if you do have an objection to being recorded or to your question being read out, please feel free to drop out of the webinar. We will make a recording of this webinar available in due course on the Llm website. And that's all of the points that I had to cover in terms of housekeeping. And with that said, we can start with the first set of questions that I will be asking Ms. Ohara, and that concern the general topic of building a career in international arbitration. So, Ms. Ohara, you started your career, as I've just mentioned, as a transactional lawyer. What was your first exposure or first introduction to the practice of international arbitration? And what led you really to move from a transactional corporate practice to an international arbitration practice?
Right. Well, hello, everyone. I'm Yoshimi Ohara. Raul, thank you very much for a beautiful introduction. Just briefly, if I may, I would like to introduce myself briefly, in addition to what you mentioned, Raul, the beautiful thing. I want to start with not a beautiful story. I started my practice about 25 years ago in Japan. And around that time, lawyers didn't really specialize in particular practice field. So I've done essentially everything, from corporate tax and securities and litigation, everything, interestingly. And because the volume of corporate work were rather large around that time in my firm 25 years ago, I did mainly corporate work, like joint venture or merger and acquisition or licensing. And then many of my clients, around that time, it was a Japanese clients. Japanese clients were involved in IP, or particularly patent litigation in United States or UK or Germany. They were sued in those jurisdictions, or, as a countermeasure, they sued back the patentee in those jurisdictions. So I've been, after I did corporate work for years, and I sort of shifted to intellectual property field, and it was guided by our clients. It's not me who chose intellectual property field, but it's more like, I was dictated by client needs. So shifted from corporate to IP. At one point in time, I got involved in the first IP arbitration. That was my very first IP, my very first arbitration. It was like 2005. So it's, after I started my practice about 25 years ago, after 10 years or a bit longer, I just happened to get involved in the very first international arbitration. And I was so much fascinated by international arbitration at that time. The reason is that before I was involved in international arbitration, as I said, I mainly handle patent litigations in many jurisdictions, mainly outside Japan, and particularly in the United States. And clients were, intentionally, deliberately, I used the term, drag into litigation in the United States. And the proceedings in the United States and Japan are so different. And Japanese clients are not get used to US proceedings, and they have to deal with deposition, discovery, and all the lengthy and costly trial proceedings. and they have to overcome, biased juries. That was really daunting proceedings for, Japanese parties. In other words, U.S. parties enjoy home ground benefit, but Japanese parties have to put up with this, so-called away game, and it was really difficult. And after having these experiences, in the first arbitration, it was again IP, and the other party was a major U.S. chemical company. And our Japanese companies are relatively small, listed, but a very small company. But the game of the dispute resolution in arbitration and U.S. litigation was completely different in many ways. But most striking differences is attitude of tribunal members and judges and also counsel. First of all, parties are trying to resolve the matter most efficiently rather than engage in timely, costly discovery or, putting much more burden on the other side to overwhelm the other side. Nowadays, we see this kind of tactics in international arbitration as well. But around that time, arbitration, I would say, was more, gentleman and ladylike practice. So parties seriously think about how to structure proceedings most efficiently and resolve such commercial disputes in a timely manner without spending too much money. And talking about tribunal members are a 3-member tribunal, and each of them were from different jurisdiction, and they understood our needs and why we are not so get used to discovery or document production, and they accommodate. So the approach of dispute resolution in national court and international arbitration was so different, and I found this international arbitration a sort of promising tools to resolve contractual disputes. So if parties are allowed to choose arbitration to resolve dispute, parties should choose arbitration rather than national court settlement. I was determined to think in that way. And since then, I got fascinated with this international arbitration and pursuing this path. And again, my career is sort of dictated by clients. So clients want me to do more arbitration rather than litigation. That's the reason why I'm doing arbitration more now. Sorry, I tried to keep my answer short, and it turned out to be longer. Apologies.
No, that's absolutely fine. That's a very intriguing answer, and thank you for taking us through that. I must say though, as a follow-up question to that, I must ask you as to whether you think that arbitration now is moving more towards litigation in terms of discovery and other things, rather than moving away from it, which was potentially what the earlier conceptions of arbitration were. Do you have thoughts on that?
Yeah, indeed. Interestingly, the similar observations were shared by U.S. patent judges. U.S., there are special court in the United States focused on patent disputes, and their judges were concerned about the latest U.S. litigation practice before general, trial lawyer got into IP litigation in the United States. IP litigation in the United States was more peaceful. Once, many practitioners saw the opportunity in IP litigation, many trial lawyers just jump into this field. And it's good in a sense that practice became more sophisticated. But as you pointed out, it became quite contentious and time-consuming, not necessarily efficient proceedings. And I see similar trend, as you pointed out, in international arbitration. And as a community member, we have to deal with, we have to tackle the issue. Otherwise, user will no longer use international arbitration. We start seeing that many users are now interested more in mediation rather than arbitration. So unless we sort of, improve international arbitration and make it more palatable to users, we'll lose users.
Right. That's a very interesting insight. Thank you. And just if you don't mind, just building off of your answer, you mentioned that users are increasingly turning to mediation. And while we're on the topic of building a career in international arbitration, would you recommend to younger arbitration or budding arbitration practitioners to also take up a course or two in international mediation as an essential complement of sorts to their international arbitration, to building up their career in international arbitration?
I entirely agree with you. If you want to serve to your clients, if you want to serve as counsel, you have to offer options. Arbitration is not the only one option. A mediation or conciliation or just a settlement discussion could be the services your client may wish to have. So to be able to be capable of providing all sorts of services, you shouldn't too much focus on international arbitration alone to meet the need of clients. And I think it's a great idea to study international mediation as well. Okay,
great, thank you. And while we're on the issue of studies, and we're thinking about international arbitration studies, mediation studies, do you think it is also equally important to have some sort of a subject matter expertise as well? In your case, I suppose it was a corporate IP subject matter expertise, and then you built onto that international arbitration. Was that subject matter expertise something that you would recommend to budding arbitration practitioners?
Yes, the short answer, yes. But the difficult part is how. In my era, as I mentioned, lawyers didn't necessarily specialize their field, and they have an opportunity to be exposed in different practice areas. So I've done corporate work, I've done a number of M&As. So I can, for example, got involved in M&A arbitration. I can see the issues immediately, or I can see flaws in the contract. And I can guess why parties come to agree to specific terms and conditions, which are not necessarily common terms and conditions. So if you have those background, you can immediately identify issues. So as counsel, you can help work with your client to build your case if you find some issues in your contract. And also as an arbitrator, you can also quickly find the issue in the disputes. So if you have substantive expertise, that certainly facilitate your arbitration practice.
Right. No, thank you. I think that's very valuable advice. Just keeping with the theme of education, there's a series of questions that we've actually received from the participants concerning pursuing an LLM degree, and in particular, where to pursue the LLM degree. Is this something that you would recommend doing outside of the home jurisdiction, or would you recommend doing it, for instance, in the jurisdiction that you eventually end up practicing in? So if you do an LLM from the US, you should think of eventually establishing a practice in the US, or is it better to do an LLM from Europe and then practice in the US? Do you have any thoughts on that?
Sure. I myself have an LLM degree in the United States, and it was a great experience in many ways. Well, first of all, it was one of the best time in my year. Mm-hmm. So much fun. I could make so many friends from different jurisdictions. So, studying nowadays is difficult because of COVID-19. You may not be able to physically engage with friends from different jurisdictions, but still you will, if you enroll into LLM degree, that will give you an opportunity to meet with people from different jurisdictions. It's so fantastic to get to know them first. And know them first means know those friends and also their backgrounds and also their countries. And on top of that, of course, you know, the most important purpose of LLM is to learn law of that jurisdiction. But in my, personally speaking, the best part of LLM was not only to learn US law, but to get to know people. Because surprisingly, you will continue to keep contact with those people that you met at LLM, and also you have an opportunity to work together. So LLM will offer, as particular LLM, which accept students from many different jurisdictions, will give you an opportunity not only to learn the law of different jurisdiction where the university is located, but also, you know, laws and cultures and politics of countries where, you know, those LLM students came from. This is a fascinating opportunity. And coming back to, you know, issue relating to international arbitration, in international arbitration, you inevitably, you know, deal with laws of many jurisdictions, of your home country, of common law jurisdiction, civil law jurisdiction, or Sharia law, or whatever. So if you're from civil law jurisdiction, it is important to study common law jurisdictions, the way they approach law or dispute settlement. So to, you know, in a short answer, I think it is important. It is quite useful, not only as an international arbitration practitioner, but as a lawyer aiming to practice internationally. It's very important to obtain Llm degree from jurisdiction other than your jurisdiction. And if you're from civil law jurisdiction, try to find good universities in common law jurisdiction and vice versa.
Right. No, thank you. That's useful. And if you'll permit me, while we're on the subject of the LLM, I should just tell our participants today that Young ICCA offers a number of scholarships to LLM programs across the world. So if you're interested in applying for an LLM program, please visit the Young ICCA website and you'll see the various scholarships that we've offered in conjunction with leading universities that offer LLM programs. So that shameless plug aside, back to the questions. We've spoken quite a bit about, you know, effectively the skills or the education that young arbitration practitioners or budding arbitration practitioners should cultivate. Are there any particular soft skills that you think are useful as well?
Soft skills. I see. Perhaps I've already expressed my view. I try not to repeat that much, but, you know, your goal is, as a lawyer, essentially serve your client. Serve your client can be, you know, outside clients or partners or senior associates of your firm. And, you know, rather than simply finish your assigned work, think about what your clients really want to achieve by this project, in this project, and try to be creative. So be, you know, not passive, but please be active and read the mind of clients. Even if they don't ask you to do, they haven't asked you to do, think about what would be helpful to them. By doing so, you can provide more creative services, helpful services to your clients, and clients will come back to you. So the key point is be active, and rather than be passive. And yeah, try to make most of every single opportunity. This might relate to, questions Saimi asked me later, but if you want to balance life and work, private life and work, you have to manage the number of cases you will handle, which means that your colleagues may take in, much more cases, but I may decide not to choose so many cases. And how do you, keep up with your competitors or colleagues? One solution is try to maximize your opportunity. Means, if you get involved in one international arbitration, try to learn international arbitration and also subject matter as much as possible using just one single case. Then in fact, you will have much more useful outcome from one single case rather than your colleagues having multiple cases at the same time.
Thank you. I think that's extremely that's extremely important advice and very, very useful. There's possibly the last question that you will hear from me. I mean, there's so many more, but we need to move on to the other topics as well. But we all know that Japan is a fairly dynamic international arbitration market, but somehow to some of us it seems a little opaque. So what advice would you really give to a non-Japanese practitioner that's interested in working in international arbitration and pursuing a career in international arbitration really in Japan?
I see. We are in the process of building capacity. This again might relate to Masaki's questions, but now government is trying to promote Japan as the seat of arbitration, and more generally, government try to increase the capacity of international arbitration for Japanese companies, Japanese parties. And to do that, we need non-Japanese, workforce within Japan. So government, again, try to ease foreign lawyers' ability to engage in international arbitration or domestic arbitration as well in Japan. So it's getting easier for foreign non-Japanese qualified lawyers to practice in Japan. So try to reach out Japanese law firms or non-Japanese law firm located in Japan to see the opportunity. I think there are lots of needs in this particular field. Well, I do not intend to use this opportunity for my private purpose, but I'm happy to receive any, interest and inquiries.
Thank you very much. That's extremely kind of you. Thank you also. That would be, I think, the last set of questions, last question really from my end. We have received a few questions in the through the question and answer box, and we'll ask those to you at the end of our session here. So with that, I turn the floor over to Saimi, and thank you very much, Ms. Ohara.
Thank you, Raul.
Thank you, Raul. We will now move on to our next topic, which is your standout career moments, Ms. Ohara. The first question, what was the most memorable moment of your first 5 years of arbitration practice?
Thank you, Saimi. It's a wonderful question, at the same time difficult question, and may also relate to other questions I received in advance. Well, perhaps if I were asked to one single moment, that was the time when asked to make a pleadings, make an oral argument, and also cross-examination at the hearing. So it was not prepared. I was asked to come to participate in a hearing, to assist the hearing and cross-examination, but at the time when I got to the hearing venue, I was asked would you be interested in doing that? And I said, why not? So that was the most memorable moment. I was so nervous, but I thought this is a great opportunity and seized that opportunity. Yes.
Thank you for sharing your story. I think it's really impressive because you could say, why not, instead of I can't. So yes, it's really thoughtful of you. Our next question will be, if you could go back in time to the beginning of your career in international arbitration, what would you have done differently?
Yes. Perhaps, I would, at LLM, when I study LLM, well, first of all, nowadays in Japan, there are universities, law schools are offering courses relating to international arbitration. In my time, there was no international arbitration program at all, but nowadays there are many programs available locally. So I would have chosen those programs first. And so likewise, when I have an opportunity to study out abroad, I would have chosen a law school which have offered international arbitration special program, and perhaps then try to find the opportunity to work in outside Japan in law firms having established sophisticated international arbitration practice. And none of them were not available in my time. So if someone, for those listeners who have that kind of opportunity, please take advantage of it. There are many programs available. And thanks to COVID-19, those programs are now available online. So that will be quite beneficial for young practitioners, I would say.
Thank you for the practical tips. You actively practice as counsel and sits as arbitrator. What is the proportion between those two roles, and which role do you prefer?
Well, talking about the proportion, it all depends on the timing. Sometimes, I mainly do arbitrator work, but like, last month I was completely swamped with preparation for submissions. So it all depends. And talking about my preference, in fact, I like both. Two roles are completely different. And the beauty of international arbitration is, nowadays there are a lot of criticism of double hot issues. But talking about commercial arbitration, I don't think, we see much of similar double hot issues, and you should take advantage of this beauty of international arbitration, means ability to switch hat. The good thing of switching hat is that once you sit as an arbitrator, you see so much shortfall of counsel work. Counsel believes that they've done everything, but usually they haven't done enough. They haven't sufficiently persuaded arbitrators. So you can see the shortfall or issues on counsel work, and then you go back to when you serve as counsel next time, you try to fix it, and thereby you can improve your counsel work, the quality of your counsel services. So to answer to your question, I like both. And the reason why I like both is because the role of arbitrator and counsels are completely different, and excitement associating to two capacities are completely different.
It seems that you've learned as working as an arbitrator that we should prepare more thoroughly when practicing as counsel.
Exactly.
Other than that, can you tell us other lessons you've learned as working as an arbitrator, if any?
Well, I always, consider whether I have prepared enough. And it is difficult to prepare very well for arbitrator while you are preparing for you are serving as counsel, because counsel work, your clients are always nudging you, you know, where's the product, how it has been, how, you know, how do you plan this, how do you manage this case? So you keep receiving requests from clients. But when you sit as an arbitrator, you don't really receive such kind of nudging from parties so often. It is institution that nudging you. And nowadays, you know, institutions provide excellent rules to give pressure on arbitrators. But to answer to your question, I always think whether I'm prepared enough when I served as an arbitrator. Mm-hmm. And also how the parties, I always think, you know, to ensure, I try to always ensure that parties feel that they are treated fairly, equally. Give opportunity to both parties equally. Do not provide any surprise to the parties. So I always think those, you know, particular points in mind when I serve as an arbitrator.
Mm-hmm. Mm-hmm. Thank you. Great. Now let's talk about challenges. So what was your greatest professional challenge and how did you overcome it?
Well, everything, you know, I'm surrounded by challenges. It's hard to tell the greatest challenge, but perhaps, you know, work-life balance and also building a team is always, has been, and still now is a challenge. And how did I deal with, how did I tackle it? I'm still, you know, dealing with, I haven't, you know, overcome it. Building, you know, a team, well, I try to speak with my team members and try to find their challenges, why they are having issues, or what kind of assistance they would need from me. So I try to reach out to team members and try to help them. That's number one. And talking about work-life balance, well, I keep apologizing to my family members. That's the reality.
Thank you for your candid answer. Now we'll talk about diversity in international arbitration. I guess a lot of participants, including myself, will be interested in hearing your story, being a female senior practitioner and also an Asian who made to the top. So I'll start with the gender issue. There is a perception that old white males are predominant in international arbitration. What do you think about this perception, and how did you deal with this perception?
Thank you, Saimi. You're from Korea, right?
Yes.
So you yourself have been, you know, encountered this, well, not white, but, you know, male senior practitioner issue on a day-to-day basis. And particularly 25 years ago, when I started arbitration, started law, I was discouraged to become a lawyer. I was discouraged to study law. I was discouraged to work. So, you know, the challenges you see nowadays in international arbitration community, to me, is much minor than those challenges that I faced in my 25-year career. So even now, you know, people just dismiss me or ignore me because I look young and I'm a female practitioner. So say, for example, when I invite general counsel of Japanese companies, and some of them do not recognize me, and they still think that I'm a, you know, receptionist. I'm so happy that I can be young enough to be a receptionist at the conference. But, you know, likewise, that perception permeates in Japan. So, you know, I see some prejudice in international arbitration community, but to me, it's quite minor. And because I have managed to tackle in my 25 career, so to me, the challenges existing in international arbitration community is not a big one, and it's not insurmountable.
Mm-hmm. Thank you. So speaking of gender issues and maybe mentoring, are there any other women in arbitration who inspire you or who you have looked up to?
Of course, there are many, not necessarily within Japan, because there are so few arbitration practitioners in Japan in any way. And even, you know, senior people, there are a few senior arbitration practitioners, but looking globally, there are many excellent female international arbitration practitioners. So I have been, being a lawyer, I have been always looking outside to find a role model. And because you are in international arbitration practice, you can see so many wonderful role models out there. And I wouldn't name one or two because there are so many.
Okay, thank you. Earlier, you already gave us a valuable advice that we should maximize every opportunities we get in order to balance our work and family issues. Other than that, can you share your tips on balancing work and family, particularly when you were younger practitioner with a young family?
Sure. Number one, outsourcing yours, you know, some work like, you know, taking care of kids or cooking or cleaning up house. You can outsource those things. So it is quite expensive, but it doesn't last forever. So please use, you know, outsourcing services. That's number one. And number two, don't compare yourself with your colleagues. Your male colleague may become a partner much more quickly, or your male, you know, colleague may have more arbitration cases or more interesting opportunities. But don't compare yourself with them. Just always think about whether you have maximized your capability or opportunity. That's number one, the second advice. And the third advice is, this is the advice I received from the top of my law firm when I took the leave of absence for the second time when my husband was transferred outside Japan. He said that, you know, you may not be able to get 100 score for work, but you actually get 80 score for work and 80 score for your, you know, taking care of kids. And if you add 80 plus 80, it means 160, more than 100. So much greater than those guys who only do, you know, work. That was the tip I got from the top of the management of the firm. That is, I think, is a good advice.
Thank you so much. It is really helpful and it gives hope to young practitioners who are struggling parents.
Yes.
Let's now move to ethnicity issue. Did the fact that you are an Asian, a non-native English speaker, present challenges or opportunities in your career?
Of course, challenges. Well, I have to tell you this. When I became a lawyer 25 years ago, I had very limited language capability, English language capability. When the client, I think it was from UK, called me up, there was no email around that time, only facsimile. Can you imagine? And they called me up and asked a very complicated, you know, commercial code question. And I didn't have any particular English language education. And I said, you know, to this client that I'm sorry, I wouldn't be able to respond to this question. Please list the questions in facsimile and send it to me. And he just said, you know, I can't, of course, I don't exactly remember what he told me, but there was no that time. I just wanted to get the needed answers, and then he hung up, and my partner lost one client. So, you know, having without English language capability was at least at the outset was really a challenge. Perhaps, you know, Raul or Saimi or Masaki, you never cannot imagine how challenging it has been. But the benefit of having such language challenges is that as an arbitrator or as counsel, you understand the challenges involving languages. International arbitration, you are not always, you know, able to speak or grasp all the languages involved in the disputes. And there's almost always interpreter issue or translation issues come up. And because you understand the challenges, you can, you know, deliver the challenges or, you know, offer the solution to challenges to arbitrators when you are a counsel. And if you are arbitrator, you can offer that solution to the parties. Sometimes, you know, English native speakers do not understand those difficulties, and they are very much frustrated seeing witnesses speaking in languages other than English. And that never happened to me. And if some delicate issue arise around translation or interpretation, those for non-native English speaker can understand and tackle those issues, which may not be equally dealt by native speakers.
Thank you. Thank you for your insightful advice. We may now move to the next topic. And before I leave the floor to Masaki, I would like to remind the participants that you can submit questions using the Q&A button on the bottom of your screen. So please do so. We will try to answer as many of your questions as possible. So please feel free to share questions. Masaki, the floor is yours.
Thank you. And thank you very much, Ms. Ohara, for your time and your excellent answers. I think you've already covered many of the topics I would like to cover. So, but the first topic I would like to discuss with you is oral pleading. I know oral pleading deserves for hours of discussions, so I would like to focus on your tips and hints for young arbitration practitioners. My first question on the point is, how did you get your first oral pleading experience?
By surprise. But Masaki, thank you very much for your question. I never prepare for, I never expect to give oral argument or cross-examination when I had the first experience. So I serve as co-counsel, and because the governing law was Japanese law, I helped prepare expert report on Japanese law. And I came, I think, a day before the hearing to the venue, and in the so-called workroom, room where, you know, all the team members got together and prepared for the hearing, which will start tomorrow, I was invited to, you know, take part in the oral argument, the specific part in relation to Japanese law. And also I was asked whether I would be interested in cross-examining expert that I prepared. And I thought, well, I was very nervous, honestly. I never done it before, but I'm the only one who knows the subject matter most. And sometimes, you know, cross-examination of expert report could be very messy when, you know, cross-examiners do not necessarily appreciate the substance of the expert report, which shouldn't be the case, but something like, you know, Japanese law. It's hard to prepare for those who are not familiar with Japanese law when, experts start to make funny responses. So I thought, how should I do? What should I do? And I decided to accept the invitation because this would be a fantastic opportunity. And perhaps, setting aside my skill of cross-examination or oral argument, I know the substance most. So I can do it, I thought I can do it succinctly and efficiently. And, that was awful cross-examination, I have to say, but at the end of the day, our client prevailed, so it's good.
Thank you very much for that story. It's very interesting. And my related question is, speaking of skills of cross-examination, what advice would you give to young arbitration practitioners who like to improve their cross-examination skills, particularly to those coming from a civil law background?
Right. Talking about cross-examination, I think, Japanese and Koreans are somewhat a little bit lucky in a sense that we have an opportunity to cross-examine witnesses in the domestic national court proceedings. So perhaps you can utilize these opportunities to prepare for examination, cross-examination in international arbitration. That's number one. And number two, just prepare and prepare and prepare. Prepare the engage in mock cross-examination and prepare for whatever scenario you can think about. But, during the actual cross-examination, you should be flexible. You should adapt yourself to the response to your question, because if you prepare a beautiful scenario and usually things do not go in that way and you will get panic. But I, sort of consider a hearing is like a sport game. Anything could happen. And you just adapt yourself. Take the best shot or take the best reaction instantaneously you have to do in the, sport matches, right? Likewise, you prepare well, but anticipate that things will not go as you planned.
Thank you very much. We have gained a lot of insights from you on oral pleadings. Then, so far, we've discussed many of your professional aspects. But the thing we've not yet discussed yet is you, Ms. Ohara, as a person. So I would like to ask many questions on these topics, but we are unfortunately running out of time. So I will ask only one question. That is, what's your favorite hobby?
Okay.
Other than law or arbitration.
Of course. Well, if I were to be asked, I would say I'm a person of art and food. I don't know whether you call it hobby, but, whenever I have an opportunity to travel abroad, I try to go to local market and see what kind of local food are sold and go to the museums. If they are old buildings, try to see old buildings to understand the culture. So talking about hobby, I would say eating, going to museums, yes.
Excellent and great answers. Thank you very much. Thank you very much again for your time. And I believe we all appreciate your guidance. Thank you very much. Saimi, would you like to take over from here?
Yes, thank you, Masaki. I see that we received a number of questions from the participants, but as we are a little pressed for time, I will randomly choose 2 questions to ask. So number 1, Ms. Ohara, would you recommend young practitioners to learn foreign language to be a successful practitioner in arbitration field?
Thank you very much. Well, depending on what is the mother tongue of this person, it's always useful to have language capability, multiple language capability. For example, I've been both in, Korean language arbitration, and Korean language is one of the languages used in arbitration, and also Vietnamese arbitration, and also Latin America arbitration. I have to understand Spanish, many Spanish documents. So if you have language capability, in addition to English or French, which are mostly used in international arbitration, that would add a great value to you. But sometimes, and also if you want to succeed in arbitrator, that is a great capability. If you look at successful arbitrators, they tend to have multiple language skills. So choose, language that are frequently used in arbitration proceeding. That will certainly, assist your future international arbitration practice. But language is not the solution. It's just a tool. So tool to great to have.
Thank you. Our second question would be, would you recommend a practitioner who is planning to have a career as an arbitrator to obtain a fellowship from the Chartered Institute of Arbitrators, or would you recommend taking an LLM course if we have to choose from both options?
Well, I have to confess first that I'm not qualified. I haven't obtained any accreditation from CIR. So that may make myself biased already. But if I were to choose between the two, because I chose LLM, I would certainly say LLM will create wonderful opportunity that will open door to many opportunities, perhaps not only relating to international arbitration, but many different fields, and open to friends in many different jurisdictions. So talking about, if I were to ask between the two, I would certainly choose LLM. But as I said at the outset, I'm biased on this point.
Thank you for your candid answer. I see that we're already over 6 p.m. here, so let us conclude our webinar here today. I would like to thank Ms. Yoshimi Ohara again on behalf of Young ICCA for your time today and for sharing your experience and insights. Also, I would like to thank all the participants who joined us from all over the world. I saw someone saying that it's 2 a.m. in the morning, and so I'm really grateful for that. The webinar will be uploaded on the Young ICCA website, so please share this video with others who couldn't attend this webinar today. Raul and Masaki, do you have anything else to add?
Nothing from my end except a big word of thank you to Ms. Ohara for doing this. We really appreciated all of your advice. It was absolutely excellent. Thank you very much.
Nothing further from me as well, and just to say a big thank you to you, all of you. Thank you very much.
Thank you very much, Saimi, Raul, and Masaki, and all those who patiently participated. Hopefully, we'll see you all in person after COVID-19.
Thank you, everyone. Have a great evening, afternoon, or morning. Bye.
Bye.